Good morning. A fantastic judgment come to the rescue of advocates because because of competency or incompetency or ideological revelations. Recently, not recently, for the past 4 years or 5 years, I think 4 or 5 years, the advocates are suspended without even initiating disciplinary proceedings. And when that was challenged, it was initially challenged by me before Division Bench Justice Sashidharan J. And unfortunately, the advocate for whom I appeared misguided me, totally claiming that the signature available on the disputed document was not that of him. And when his applications from Bar Council was called for and tallied, I could not say anything because signature was that of the council. That resulted in suspension valid good. And that time the court has drafted in a different way, holding that under Section 6 of the Advocates Act, the Bar Council have power to suspend it. But I do not know whether that went up to Supreme Court or not. But here, Madhya Pradesh Indoor Bench, AR 2022, page 61, Vishal D. Ramteke vs. State of MP, delivered a judgment on 5/10/2021. Aptly and literally, logically, statutorily interpreted the Advocates Act. They did not concentrate on the gravity of the misconduct or not. They only went through the statutory provisions of the Advocates Act. See, they have referred Section 35, 36, 37, Article 226. You see, they have discussed about Section 6 of the Advocates Act. The functions of the State Bar Council shall be to entertain and determine cases misconduct against advocates on its roll, to safeguard the rights, privileges and interests of advocates on its roll, to perform all other functions conferred on it by or under the Act, to do all other things necessary for discharging aforesaid functions. Then they say what all are the provisions for disciplinary action. Section 35. Then Section 37 is appeal. Now the division bench, after referring several Supreme Court judgments regarding the authority of various other disciplinary committee who has got power to punish or suspend the practice of their role. Here they say this is equally settled that if a statute prescribes a thing to be done in a particular manner, it has to be done in the same manner and other methods are known to law. The statute empowers a particular authority body to take a decision. It is only that body which should take a decision and none else in the hierarchy. However, higher he may be unless statute permits him to do so. Then they say there is no material before us to show that State Bar Council has referred the case of the petitioner to the disciplinary committee to take a decision. No material is also available to establish that disciplinary committee has taken up the matter before placing the petitioner under suspension, and the petitioner and Advocate General were put to notice. As noticed above, Land Council of Bar Council has fairly admitted that only after placing the petitioner under suspension, disciplinary committee has initiated action. Therefore, they say, then they have well interpreted Section 6. Section 6 upper set is concerned. The heading itself makes it clear that by the said section, functions of the State Bar Councils are defined. The functions so prescribed can be translated into action as per other enabling provisions of the Act. Disciplinary action against an advocate is also one of the functions of the Council. It can be taken only on consonance legislative mandate ingrained in Section 35 of the Act. Then the Bar Council has raised another objection stating that the petitioner may file appeal under Section 37 before the Bar Council of India. Then they say the remedy of appeal to Bar Council of Section 37 is available only when order is passed by the disciplinary committee. In the instant case, as discussed above, the disciplinary committee has not taken a decision to suspend the petitioner. Thus, remedy of appeal 37 is not available to the petitioner. Therefore, Article 226 was entertained and the suspension order was revoked, cancelled, quashed, and they left it to further process of disciplinary committee as guideline. So, however, they say they are not going to the merits and demerits of the allegations of the petition. So, this will be the judgment. The judges should not be more sensitive. Nowadays, judges are sensitive, not only sensitive. Sometimes overactivism is also prevailing. They are thinking too much of them, and they fail to note that they are also sovereign kings who rule the country for few years, few days, few decades, and thereafter he will be only part of history. And these some of judges by deviating the morality, the judicial discipline, express their view sensitively. Whatever may be, the courts must be more sensitive, but only in writing, not in dealing with the matter. While discussing the judgment, judge may say anything, obey their dicta, but the judges should not trespass into ipsi dixit area and passes certain orders. Whatever it may be, we have to face these days also. But I think if anybody aggrieved by the Tamil Nadu Bar Council suspending him, may approach and refer this case so that these cases may be referred to Supreme Court, and there may be a Article 142 declaration of law about this area, whether the Bar Council has got power to suspend even without initiating disciplinary action. Question of adi altum partum, principle of natural justice. A pure theory, all should be kept in mind. And since we are in the year 2022, we are not supposed to deviate the prevailing law right from the Greek, Roman Empire proceedings and our Westminster medical legal jurisprudence. Okay, best wishes. This is the way some they have referred so many judgments wherein competent authority, the decision making process, all these things has been discussed. Therefore, you let see, we should not be hurrying. Only say several cases are referred only because it is referred by the High Court. Bar Council is an independent authority. Advocate General is leader of the bar. It includes the judges, leader of the bar. Advocate General, leader of the State Bar, includes the judges. because he is having only first audience before the court. Therefore, when the cases are referred by the judges, why the bar council taking on file as a suo motu complaint blindly? That is the main problem. Here also, yes, of course, in some cases, it appears that the suspension seems to be correct procedure because of the behavior of the advocates. But however, this adi altam principle, due process of law should be followed. You take this incident suo motu. Bar Council has got power to take suo motu action, refer to disciplinary committee, serve him notice 24 hours and get explanation, serve notice to Advocate General, then suspend it. Then that suspension comes under section 35. This judgment did not say that interim suspension is valid or not. Yes, best wishes.